Good evening to one and all. Welcome to today's seminar of the day, Perspective and Experience in Cross-Border Insolvency. I would like to invite our head of IP Net West, Mr. Uday Raj Patwardhan to give the welcome address.
Welcome to you all, friends. We are going to have the topic of perspective and experience in cross-border insolvency as the topic. Today we have two speakers. One of the speaker is Prof. Ravinder Gupta and other one is Mr. Lajay Jain. Both are IPNet members, and of course we are working under the guidance of our Dr. Ashish Makijaji, who from US in the morning at 6 o'clock is there to guide us. We have been able to establish this IPNet in a remarkably very short span, and this has become a very vital platform for IPs across India. We have a new topic today, cross-border insolvency, and the two speakers that we have today have got immense expertise and hands-on experience of that topic, and that makes it very important. So I'm very confident that the IPs attending today, most of them are IPNet members. If not, I would request them to become IPNet members as early as possible. And with this, now I would hand over to Rajesh Shah to introduce the speaker, first speaker today, Mr. Rocky Ravinder Gupta.
Hi, it's my pleasure to introduce Rocky Ravinder Gupta, Sir. Sir serves as the President of Turnaround Management Association India, that is TMA India chapter of TMA Global. Specializes in cross-border insolvency and restructuring. In addition to this role, he is a lawyer, Insol Fellow, member, accredited mediator, and an insolvency professional. Rocky Sir has significant experience as a restructuring and insolvency lawyer, advising banks, creditors, and debtors on restructuring, insolvency, workouts, banking, and distressed debt transaction in range of industries including real estate, construction, healthcare, mining, and manufacturing. Today, Sir will share his thoughts on his perspective and experience in the cross-border insolvency and restructuring. Over to you, Sir.
Thank you, Rajesh, for the introduction. Occasionally meeting after a very long time. And let's make this session a bit interactive. In terms of, let me ask questions. If you can respond to that, that would be very good. Please let me know if I'm audible to you.
Mr. Gupta, I think your voice is echoing as if you're speaking from a very far off place. I mean, I don't know.
Actually, now is it fine? Better?
It is, yeah, it is better, but it's still echoing actually a lot.
I don't have another, I mean, I'm not put on another device, but I don't know why it's echoing. Let me see. Vijay, can you open up this door? Probably I'm in the conference room. That is the issue. Is that fine now?
Yeah, it is better. It's much better. Yeah, please go ahead. And friends, before I think he starts, may I request everyone to please open our video so that the interaction is much better. As I always say, we like to see smiling faces. This is not a faceless meeting. So I think I'll request everyone to please open their videos if possible. Yeah, thank you.
I hope everyone can see the shared PowerPoint. We are able to see. Okay. So let me ask every one of you, what do you understand or what do you think when we talk about cross-border insolvency? Any ideas? Mostly when we talk about cross-border insolvency matters, it is mainly due to certain different reasons that the debtor may have economic affairs with a foreign counterparty. This economic affairs refers to a debtor engaging in financial or commercial transaction with entities located outside its home jurisdiction. In today's talk, I will be using certain words, home jurisdiction and a foreign jurisdiction. When we talk about a foreign jurisdiction, this would be something like outside India. When I talk about the home jurisdiction, it would refer to either India or to some other jurisdiction or some other country where, but that would be completely relative to what I'm speaking on, right? So, for an example, regarding this economic affairs with foreign counterparty, the example that I can give is that an Indian manufacturing company enters into a long-term supply agreement with a German part supplier. And if the Indian company becomes insolvent, the German entity may have legal claims, and the insolvency proceedings may need to address foreign involvement as well. Interest in property located in more than one country. This situation arises when the debtor owns or legal or equitable interest in assets that are located in multiple jurisdictions. For example, probably some business activity or a subsidiary in Dubai or Europe or US. So this may have the debtor may have different properties, assets located in different jurisdictions, and that at that point in time it becomes essential to delve into cross-border cases. Some of the companies in India or abroad would be taking some sort of a loan or money from foreign creditors. So they might be domiciled in other countries. So this would eventually affect how it is put, how the insolvency is going to take place. Now, this is something which can be part of a claim, or it could be where the foreign creditors might file something. If there is an establishment in their jurisdiction, they might file some sort of a insolvency application, or proceedings may be initiated by them in their specific jurisdictions. Contractual obligations governed by foreign jurisdictions. This may include choice of that confer authority to foreign courts or require interpretation under foreign legal principles. Actually, this is, I don't know whether we have this in India or not, but when you talk about arbitration, the seats and the law can be different from where you are placed in terms of arbitration agreement. Similar thing can happen for insolvency as well. Then obligations that have been incurred outside the debtor's home country or that are to be performed abroad. This effectively typically refers to liabilities that originate in or must be fulfilled in a different jurisdiction. The example of this that I can give is that Australian construction firm undertakes a turnkey project in the Middle East and hires subcontractors locally. In case of insolvency, the liabilities arising from these foreign operations, like unpaid salary or wages or breach of service contracts, may trigger cross-border legal claims. So effectively, in these 5 circumstances, cross-border insolvency can happen. Any question at this point in time? Should we go ahead? When we talk about cross-border insolvency, it is not that every jurisdiction where the company has establishment. We'll talk about establishment and other terminologies later in this presentation. So just for the sake of clarity, establishment is a place where a company has its economic transactions going on, right? So if there is establishments in different jurisdictions, how do you think the cross-border strategies can be taken care of? And these are some questions that need to be answered. If debtors have assets in creditors' contracts of such as subsidiary abroad, many questions can arise because, ladies and gentlemen, cross-border insolvency is a very expensive proposition. You need to have a cost-benefit analysis, and you need to know which jurisdiction is most likely to make money for you in terms of settling up with the creditors and like Section 53 in the IBC, how they are going to happen, and whether there would be extra proceeds which will come out of the sale or by selling of that company or that specific subsidiary in a different jurisdiction, and how it is going to be taken care of, because every jurisdiction may have different waterfall arrangements. I'll just open up all these. All countries have their own laws and regulations. And it is very essential for a cross-border strategy to understand whether the proceedings in a jurisdiction A, state A, will be recognized in state B or not, and vice versa. What would be the transborder effects of proceedings in terms of the laws which are governing insolvency in specific states, in a foreign state as well as the home state? Regarding the powers of insolvency practitioners, whether they're governed by the Model Act. India is not a signatory to the Model Act. So how can we take advantage of the Model Act in some other state? You must know about the Jet Airways case when the NCLT Mumbai dismissed the application of the Dutch representative, and it was taken up by NCLAT on the basis of committee that we should give access to Dutch representative in the Indian insolvency proceedings. So these things are evolving, and over a period of time, it should be evolving. Because unless you do that, since India is now getting a lot of inward investments and outward investments, so any company which gets into insolvency may or may not have international access to different markets and maybe having some sort of an establishment in different jurisdictions. Moreover, different rights are conferred by the insolvency laws of different countries. So we have to check whether these laws are actually coordinating with each other or not. In terms that we need to understand how we come to. I'll be telling you more about this in a detailed manner as we go ahead. And the very important question as to recognition, execution of judgments. When we talk about this, most of the lawyers would understand that executing a judgment outside the home country may be a difficult proposition. So, most of the times, some of the jurisdictions do not recognize Indian judgments. Probably they will have to go to a high court to get them executed, or there must be some sort of a mutual agreement within the two states wherever you want to execute that judgment. We'll skip this. Now, effectively, we have two sort of legal systems in the world, which is effectively common law system and the civil law. When we talk about the common law system, it was, if you go into the history of common law, it used to be a written commands called writs when justice needed to be done in England. And since writs were not adequate to cover all situations, equity courts were eventually formed to hear complaints and develop suitable remedies based on equitable principles. If you look at a statutory law or a constitution of India, it goes into hundreds of pages, which takes care of most of the situation that might crop up in the near future. But when you look at the US Constitution, which is only of 4 pages, they have defined their constitution in exactly 4 pages, wherein the courts are now giving out judgments which become effectively the precedents where the other courts takes cognizance of those judgments, and the law is formed in that manner. And most of the times, I would say, not in India, but I would say in US, lawyers makes the law because they set up precedents which are used as law in future. When we talk about the civil law system, most of the European countries follow civil law, which may be traced back to a system of rules created by the Roman emperors. The basic concept and norms of civil law are written in codes and legislation. They don't go beyond the codes and legislation. The precedents are effectively secondary source of law, whereas in the common law system, they are the primary source of law. The jurisdiction that you follow the civil law are effectively China, France, and Germany to be, these are the major jurisdictions which follow the civil law. Now, when we have spoken about these two, there is a lot of difference between common law and civil law system. And when we go to the insolvency part of these systems, they're completely different, and we need to synchronize our strategy to understand both these systems and how best effective can we use these two systems to set up a strategy where there would be a good probability of a success. So before we go forward, I would like to take you through the theories of cross-border insolvencies. I'll take the territorialism first. Territorialism is founded on the idea of state sovereignty, where, like, for example, when the IBC came into being, we were only looking at assets within India, not outside India at that point in time. Yes, over a period of years, we have evolved a lot. But territorialism is a concept where a jurisdiction will have only claims from their own jurisdiction. The assets would be used for the benefit of their own jurisdiction. Outside entities may or may not be allowed to get into that specific insolvency procedures. This is one of the concepts of territorialism. Whereas universalism is a concept where it is thought, and this is only a thought. It cannot be converted into practical things, where it is provided in universalism that there would be a single forum applying a single legal regime to administer the debtors' assets and liabilities on a worldwide basis, which cannot happen in the next 100 years, I believe, because every country have their own laws, own regulations, own secondary legislation and primary legislations, and to create something out of it through a single legal regime to administer the debtors' assets and liabilities may not be possible. So there came up a new theory which was called the modified universalism. This theory is to date the dominant approach for addressing cross-border insolvency. Modified universalism incorporates the philosophy of universalism, but accepts that a country may only unilaterally control its own territory and laws and uses private international law and rules and regulations and shapes all these private international laws to fit global insolvency in line with the universalist regime. The country does not try to coordinate its legislation with the other country's legislation, but creates a system that would facilitate the cooperation between the different jurisdictions to have an impact and a positive impact on the cross-border insolvency cases. Like we saw, I can only, give you an example of Jet Air when the Dutch representative with the Indian insolvency professional entered into a protocol. And the protocol is nothing simply but simple rules which have been agreed to by the two insolvency professionals, one from the Holland and one from India. So these were the rules which were created to facilitate cross-border insolvency for the Jet Air. So effectively, the most dominant approach at this point in time in cross-border is the modified universalism theory. Please let me know if you have any questions on this or any clarification is required, because this is something which will be using most of the time, these words. Okay. The framework of insolvency laws. Let's talk about IBC. Let's talk about IBC. When we talk about IBC, the first thing is that there has to be a default, a debt and a default. That's common across jurisdictions. Actions by individual creditors against the bankruptcy company or the debtor are frozen. Individual pursuit is stayed. And an automatic stay, which is called the moratorium, there is some difference in the terminology that we use internationally and India. So moratorium is used in India and automatic stay is used in different other jurisdictions. So these are the basics of insolvency and bankruptcy, which are common to all jurisdictions. The assets are pooled together, which becomes available to pay the creditors, replacing the piecemeal seizure of assets by individual creditors. This feature is eroded as a universal principle in that different jurisdictions provide different exceptions. There might be different exceptions in different jurisdictions. So when you think about a strategy to have a cross-border insolvency case initiated in different jurisdictions, these things need to be taken into account. One of the important issues that come up in international insolvencies is the policy considerations. If you look at the model law, it talks about that any policy which is manifestly contrary to the laws of that country needs to be taken into account in terms of that the foreign main proceeding or the foreign non-main proceedings can be denied. I'll talk about the foreign main. I think we keep this policy consideration path somewhere so that I come back to it. Then the sources of legislation are different in different jurisdictions. Gateways and commencement obviously starts with a default, and the debt is not paid. Commencement starts. Effects of initiation is like what we have in India. There is an automatic stay, a moratorium. Claims will need to be filed, and the appointment holder, the insolvency professional, would start the process of insolvency, which may be different in different jurisdictions. Then the administration needs to be done by the insolvency professional or the appointment holder. Distribution in India, we do it under Section 53. Probably the waterfall may be different in different countries, and the cost of administration is effectively what we call the CRP expenses that has to be taken care of by the creditors. It could be taken care of by some sort of a regulatory body in some jurisdictions. So you'll have to see what is the state of insolvency process in different jurisdictions. I'm keeping it short because I have a less time. So if you don't understand something, you can please ask. Now let's talk about some terminologies which are used internationally. Probably Part Z, when it becomes effective, will be taking care of all these terminologies. So a foreign proceeding means a collective judicial or administrative proceedings. Effectively, we in India see it as a judicial proceeding, but in some civil law countries, it is an administrative proceedings, including an interim proceeding pursuant to a law relating to insolvency, in which proceeding the assets and affairs of debtors subject to control or supervision by a foreign court for the purpose of reorganization or liquidation. So when I speak in Holland about this foreign proceedings, then Holland becomes my home jurisdiction and India becomes the foreign proceedings, and vice versa. So if I'm speaking in India, some other jurisdiction would, when the proceedings started, that would be foreign proceedings. Foreign main proceedings. That is where the COMI is situated of the debtor. We'll be coming to COMI in detail because it's a very important concept and a concept which is rebuttable. In India, if a company is registered with Mumbai ROC, the proceedings have to be initiated in Mumbai NCLT. But think of a situation where the Mumbai company registered in Mumbai ROC starts a proceeding in Delhi NCLT. Is it possible? It's not possible in India, but let's say Europe or some other jurisdiction like UK, US, Canada, this can be possible, and it's called forum shopping. Forum shopping is supposed to be bad word, but I don't think it's a bad word because you are choosing a jurisdiction which helps you get restructuring done very fast. And also all these countries like US, UK, for that matter, Holland now, Singapore, are providing these sort of services to restructure companies very fast because it gets business to these countries as well. So we'll talk about it later. Okay. So foreign non-main proceedings. So if there are two proceedings in two different jurisdictions, for example, there's a company in Holland, which is a parent company, which is a holding company, having subsidiaries in Italy, Spain, and say UAE, where the COMI situation situated become the foreign main proceedings, and where the COMI is there is main proceedings, whereas other subsidiaries where the insolvency proceedings are started would be designated as foreign main proceedings, and it has to be confirmed by the courts of that specific jurisdiction. One of the major features of the Model Act is that there has to be an establishment. And what is establishment? Any place of operation where the debtor carries out a non-transitory economic activity with human means and goods or services. There they can start a foreign non-main proceedings. However, if I have assets in Spain, but no economic activity going on, then that asset in Spain, we cannot start a non-main proceedings. So the word establishment has a very, very specific meaning, and it has to be taken care of before we even get into a strategy formation for a cross-border insolvency initiation. Foreign representative means a person or a body appointed on interim basis or final basis authorized in the foreign proceeding to administer the reorganization or liquidation of debtors' assets. Foreign court means a judicial or the authority competent to control or supervise a foreign proceeding. Like I said, judicial authority or an administrative authority. In some civil law countries, there are administrative authorities to control and supervise insolvency proceedings. So these are the effective terminologies that are used. Then there are some the terminology called burdensome assets, assets that have no value or significant value. We have center of main interest. We'll be talking about it. Then we have one is the priority claims, a claim that will be paid before payment of general unsecured creditors, which we call as super priority for us. So all these terminologies are important to understand. We have a similar word for that in India as well, but might be a little bit different. For example, insolvency professional is sometimes called an appointment holder or a liquidator in some countries. So before we even understand what COMI is, many years back, around 50, 100 years back, many countries within specific regions understood that insolvency needs to be coordinated and controlled so that the economic transactions between in those countries are taken care of. So in Africa, there was LOHADA, which was a harmonization of insolvency legislation within Africa. The Montevideo Convention looks at three countries of Argentina, Paraguay, and Uruguay. Then we have the European Union regulations controlling all the 36 countries in the European Union. Some countries have not accepted the insolvency directive. Then there is a Nordic Bankruptcy Convention, which looks at putting up certain rules and regulations between Denmark, Finland, Iceland, Norway, and Sweden. And there are interstate treaties and interstate agreements, which look at some sort of coordination between different governments, different jurisdictions to take care of multilateral insolvencies. Because these sort of insolvencies are very complex and sensitive to the issues involved. And it is better to have some sort of a treaty in case, like India is not a signatory to model law. Probably it might, and most of the business are conducted with UK and US. So probably better to have some sort of a treaty with them in terms of keeping out any insolvencies. So, so these were the earlier slide looked at the regional seeking initiative. Then there was some initiative that have been happening for last many years in terms of international initiatives. So Model International, the CONCODA, it's a Cooperation Act and Cross-Border Insolvency agreement between different countries. This was a Model International Insolvency program which started sometime way back, which was done in coordination with Insol, International Bar Association, Committee J of Section of Business Law, International Insolvency Institute, and the American Bankruptcy Institute, with help from Asian Development Bank and World Bank. Then we look at the Universal Model on Recognition and Enforcement of Insolvency-related judgments. This is a very new law, which was adopted in and Insol and IBA participated actively to create this work of Insol. And there is an Insol model on cross-border insolvency. This was the first one, and the second one became the Insol model on cross-border insolvency, wherein the India is not a signatory, but I think there are more than 50 members who are signatories to this model law, and it helps these countries or jurisdictions to take on cross-border insolvencies in a much more effective way, because there is a set rules and regulations which take care of the cross-border insolvency issues that crop up because of some sort of a mismatch in the legal system or the statutes between different jurisdictions. Now let's talk about COMI. Effectively, COMI should be placed where the registered office is situated. But most of the times it doesn't happen that way. Internationally, most of the times COMI shifts from one jurisdiction to the other jurisdictions. And it is not done just to take advantage of the speed of restructuring, but also to take care of a lot of other things. Effectively, the COMI should be where the debtor conducts the administration of his interest on regular basis and is therefore ascertainable by third parties. The international ramifications of COMI determinations are very important. The moment the main insolvency proceedings is recognized in the COMI jurisdiction, it will enjoy automatic recognition of broader powers in foreign courts. Most of the times, forum shopping is risky, but there are various means and ways where a jurisdiction COMI can be changed from one jurisdiction to the other jurisdiction. Effectively, UK courts look at anything not beyond 3 months. So if in one of the cases, I don't remember the name of the case, but in one of the cases, one of the holding company was situated in Germany with subsidiaries in UK and France. So to use the English scheme of arrangement, they needed to change the COMI to England instead of Germany. So before even going for a restructuring process, they made the subsidiary, which was in UK, as the holding company. And German company became a subsidiary of the British holding company. And after 6 months, they applied for the schemes of arrangement under the using COMI as in UK, and it was allowed. More notable cases which look at change in COMI is one of the main important cases, the Eurofood case. Probably you can look it up when you have the time. You can just type Eurofoods and yes. Udaraj, you are going to.
Yes. I was just saying, if the rejection office is just a letterbox address, then how do we look at it?
Pardon? I didn't get you.
If the COMI registered office address is only a letterbox address, then how do we look at it?
I'll come to it. The next slide is on that. Okay. So let me go to the next slide. So to determine COMI, these factors would come into play, and various courts in different jurisdictions have ruled in different ways. The location of the debtor's headquarters and registered office. The location that the creditor is reasonably believed to the place of business of the company. I'll take you through some case law so that you understand this better. The location of those who actually manage the debtor, which conceivably could be the headquarters of a holding company, the place of the supervision or the general oversight and strategic oversight of the group. Like you said, if there's a letterbox company, probably a letterbox company would come from Caymans or Bermudas or Cyprus or some other jurisdiction. But probably the decision makers are sitting in UK or US or any other jurisdiction. So, and the creditors are dealing with them. And as a third party, they understand that since the promoters are sitting on, they can rebut the presumption of COMI in tax havens and come down to US or UK. Okay. The location of debtors' primary assets, the location of majority of debtors' creditors or of a majority of the creditors who would be affected by the case, the jurisdiction of law would apply to most disputes. Recently, Insol and some other organizations have come together to bring about certain change in terms of COMI determination. So if I am taking a 500 million loan as an ECB or 700 million ECB, probably like arbitration, the seat and the law are defined. Probably COMI could also be defined in that specific. And if that is done, the COMI would be fixed. It cannot change or it cannot shift. So these are some things which are going on in this ecosystem of COMI. Let's see where we reach once these things are taken care of, either by model law or by various jurisdictions, ratifying some sort of a convention which might come up in the future. The other consideration being the place where the board of directors or managers meet, the place of residence of the directors, the place of main commercial transactions, the location of the bank accounts, the location of the employees and of human resources function, and the location of restructuring negotiations with creditors. Now, while I was talking about Eurofood was a subsidiary. It was a subsidiary of Parmalat Italy, registered in Ireland. Was paid into insolvency. Italian authorities challenged Irish COMI. It was not granted. Then the case went to the European Court of Justice. It was held by the European Court of Justice. That the company's registered office is presumed to be COMI, and that's clearly rebutted. And the rebuttal presumptions could be all these that we have just spoken about. In Oil Exceptional.C Limited, this is a case of 2008 from UK High Court. A Canadian parent company shifted the operations of its UK subsidiary to UK. Before entering administration, the UK court found that a debtor's center of operational control and creditor engagement was in UK. COMI was to be in UK, despite the parent's domicile in Canada. The ruling validated deliberate COMI shift done transparently and well in advance. So courts also accept the fact that if it is done, if the COMI shift takes place and the COMI shift is taking place without malified intention, they are happy to grant it. Like I said, most jurisdictions allow this because it is bringing a lot of business to those jurisdictions. When we look at Lehman Brothers, 8 to 9 billion was the legal cost. What if Indian jurisdiction had some sort of an arrangement where companies, debtors from different jurisdictions come down to India and have restructuring done through the Indian courts? The business would come to India. Lawyers, accountants, company secretaries, management consultants would make money out of it. So this is the reason why UK, US, for that matter, Holland now, Singapore are the jurisdictions where most of the restructuring take place. And very interestingly, what do you think is the main factor for a company to get Section 11 foreign main proceedings recognition in US? Can anyone tell me? One factor which would allow you to get yourself recognized as foreign main proceeding under Chapter 11. Chapter 11 is the equivalent of IBC. When I was doing my Insol fellowship course, Professor Ray Warner came to the class, and he gave us a very, very beautiful example on how you can have the US jurisdiction as a restructuring tool. And this is not a joke, this is an actual fact, which I'm going to tell you. So one of the companies wanted to get restructured into under Chapter 11. Chapter 11, it would effectively make it a foreign main proceedings. Chapter 15 would give you a recognition as a non-main proceedings. So, and this is a fact, not a joke that I'm telling you. So one of the person left his umbrella at the airport. And that umbrella was his asset. Since it was in US, he got the factor to put his company into Chapter 11 because of simple umbrella, and that's why we call it an umbrella rule. So if you have an asset, maybe it is $200, $300 in a bank account, or you've given it to someone. Once your asset is in US, you have the chance to use Chapter 11 to your own benefit. The next, let me just go through another case, Agroker DD, insolvency recognition under Chapter 15. So Agroker, a large Croatian retail and food conglomerate, filed a proceeding in Croatia and sought recognition in the US. Now, since the proceedings were filed in Croatia, US bankruptcy court recognized Croatian proceedings as the foreign main proceedings under Chapter 15 and confirmed that Croatia was the COMI, and reaffirmed that non-main proceedings start in US. So a lot of COMI shifting takes place with different means and ways. The timing as to the COMI is also very important. Some jurisdictions might say COMI is to be determined at the time of filing the application. Some jurisdictions may say when it comes up for hearing. At that point in time, the COMI has to be determined. So there are two different time points where different jurisdictions may ask for COMI determination. Most of courts in UK, US, Singapore, and Holland, Netherlands, have flexibility with respect to all these factors to bring COMI to their jurisdiction. And subsidiaries COMI is not presumed to be the same as their parent. So subsidiaries, for example, in UK would have to start a scheme of arrangement. They have to do it on their own. If the parent company is going to get into an insolvency process, probably subsidiary making profits may be left out, and that is determined by the group insolvency. Probably in some other webinars this might be discussed. Okay. We have already discussed this. Now let's go to the Unstall model law. We are not a signatory to it, but we have followed to an extent the rules and regulations within Unstall model law in the Jet Airways case. The preamble of the model law, I'll just read it out to you. The purpose of this law is to provide effective mechanism for dealing with cases of cross-border insolvency so as to promote the objectives of cooperation between the courts and other competent authorities of this state and foreign state involved in cases of cross-border insolvency, greater legal certainty for trade and investment, because if you understand that these are the things that can happen to us and these are the things that cannot happen to us, it would help you in preparing your trade and investment strategies. Fair and efficient administration of cross-border insolvency that protects the interest of all creditors and other interested persons, including the debtor. gives more leeway to the debtors and creditors to look at their takeaway in terms of insolvency. But I would say that timelines need to be very sacrosanct. Protection and maximization of the value of debtors asset, which is also one of the preamble lines within the IBC. Facilitation of rescue of financial troubled businesses, thereby protecting investment and preserving employment. Very importantly, it looks at turning around companies which are financially troubled even before they get into insolvency. When we talk about Instral model law, there are 4 things that we need to take care of. One is access, recognition, relief, and cooperation, coordination. We'll talk about these in a little bit of detail. Access. So what is access? The access provisions address both inbound and outbound. In terms of outbound, Article 5 authorizes the person or body administering a reorganization or liquidation under law of the enacting state act in a foreign state. So, to put it simply, if an insolvency representative in India has to go to Singapore to access the courts there, can go. There is a right of direct access under Article 9. Under Article 10 of model law, that if the Indian representative, we'll talk about India and Singapore to be very clear on what I'm saying, because the wording is going to be difficult to understand on foreign and home text. So if application is filed by an Indian RP in a Singapore court for recognition of any sort of a proceeding, this does not make the foreign representative, that the Indian IRP, subject to foreign representative or the foreign assets. However, there is a proviso there in Article 10 that the foreign courts can impose penalties for any misconduct by the foreign representative according to laws in the enacting country. The Indian IP or the representative may be subject to scrutiny by the regulators in case there is a misconduct in the international or in a Singaporean court. Article 11 talks about application by a foreign representative to commence a proceeding under the laws of enacting state. If there are certain conditions, if you read the model, there would be certain conditions there. So all those 3-4 conditions are there. So if all those conditions are satisfied, the commencing of such proceeding are otherwise met, and it does not otherwise modify the conditions under which an insolvency proceeding may be commenced in the enacting state. So it is very easy. You need to just have a debt default. There need to be a certificate or an order from the Indian court to access Singaporean jurisdiction. Participation of foreign representative in a proceeding under laws of enacting state relating to insolvency. This is Article 12, Article 12. So a foreign representative is entitled to apply to commence and participate in a proceeding if the condition for commencing such a proceedings are otherwise met, and the foreign representative may be allowed to participate in the domestic insolvency proceedings, subject to the matter of access to be prescribed by subordinate legislation. So if you remember that when in the Jet Airways case, when the Dutch representative initially put in an application to NCLAT, he was barred from attending the COC meetings, but later on he was allowed to in the COC meetings, but without any right to vote. So this is regarding the access to different courts outside India. Now we talk about the recognition part. Article 15, application for recognition of foreign proceedings. So if a certified copy of the decision of the home country in India, certificate from So if there are 2, 3 proceedings, then certificate from different courts, different courts in foreign jurisdictions, that these proceedings are pending there. And in case there is no evidence to that effect, except there is some sort of a order of the Indian court commencing insolvency proceedings against a company which has an establishment in the other country, the insolvency representative in India can file for recognition, irrespective of the fact that he has those documents or not, which is confirmed by Article 16's presumptions concerning recognition. So if a file is, if a case is filed in a foreign court with a foreign court regarding the Indian insolvency judge order of admission, along with certain other documents, the court would presume them to be true. It is the prerogative of the court to presume it to be true, and they can accept and admit that application. In the absence of proof to the contrary, the debtor's registered office or habitual residence in case of individual is presumed to be the center of debtor's main interest, that is common. Decision to recognize the foreign proceedings. Mostly, if there is no policy matter which is manifestly contrary to the country's laws, the courts would admit and recognize the foreign proceedings. There have been certain case laws. Do we have the time to go into the case? I don't think so. Let's go on that. So in one of the matters, let me just give you one example of this. It's a very interesting case. Yeah. This will federal products liability litigation. You can just write FEDRA, EPHEDRA, products liability litigation. This was a Canadian insolvency representative, a Canadian debtor, went to the US court for recognition of Canadian insolvency proceeding as foreign main proceedings. And it was allowed. Thereafter, Canadian court entered an order approving claims resolution procedures. Since this was something to do with product liability, that means there was some sort of a dispute regarding the product's capability. US courts initially said that they would not give the recognition based upon one of the main policy requirements in US about a jury trial. They said that how can you say that a product is defaulty, but if there is no jury trial, because jury trial is some sort of a fundamental right there. But then it was manifestly contrary to the public policy of US. But the courts said that, okay, what you do is you get into mediation. And once you get into mediation with the creditors, let's see what comes out of it. Despite it being a manifestly contrary to a public policy of US, the court said that as for the contention that the denial of right to trial by jury was manifestly contrary to the public policy of the US, the court held that neither the US provisions was equivalent to Article 6 or any other law prevented a court from recognizing and enforcing a foreign insolvency procedure for liquidating claims because the procedure did not include a right to trial by jury. Effectively, what I'm trying to say is that public policy is an important part of denying a recognition, but it has to be used as per model law and as per various judgments in US and UK to be used in a very rarest of rare cases, not in every case. There are other case laws as well, but we do not have the time to get into that. Let's get to the next part. Like when an order of admission is passed, most of you have read that order of admission, wherein it would say this IP is appointed, moratorium is going on, has started, there would be no individual litigation, it would be collective litigation. So when we talk about model law, there are three articles, Article 19, Article 20, and Article 21. Article 19 effectively deals with interim relief. For example, faster interim relief is to be sought under Article 19. Article 20 automatically comes into play when the application is recognized of foreign main proceeding in that jurisdiction or foreign non-main proceeding. So it would be automatic stay, no individual litigation, collective action, all these things come into play. And Article 21 is the court's prerogative to give relief after recognition. So these three reliefs are totally different from each other. Article 19 prior to recognition, Article 20 after recognition, and Article 21 any other extra relief that a creditor or a financier might ask, or the other representative, the foreign representative may ask the court for the effective resolution of the insolvency process. You have got access, you have got relief, recognition, and you have got relief. Let's take an example, an Indian court, which is the foreign main proceedings, an Italian court with the foreign non-main proceedings, and a UK court with the foreign non-main proceedings. How do you coordinate all these efforts? How do you put up a strategy to create a clear path for the cross-border insolvency? Article 25, 26, and 27 actually deal with this. Cooperation and direct communication between a court of this state and the foreign court or foreign representative. The courts will talk to each other. Article 26 deals with direct communication between the IRPs and the foreign courts. And Article 27 speaks about the forms of cooperation. Without this sort of a cooperation, cross-border insolvency cannot work. Why do we need this cooperation and communication? Like we said, spoke about earlier, the different legal systems, there might be different processes, procedures within each legal system, civil law jurisdiction, having some sort of the cooperation with the common law system, that is going to be difficult to coordinate, but it has been done. Some jurisdiction might be looking at a theory of universalism or a territoriality theme that would be different. Very importantly, there have been sittings between US courts and the courts in China, in Singapore, where there is a huge amount of time difference. The official time do not mix with each other. So different time zones need to be taken care of. Sometimes the courts sit at night also to take care of, to talk to judges in different jurisdictions. Then how to take care of translations, languages. Which language will they communicate in? Most of the times, English is a language which is universally applicable or used for communication. But again, for example, a court in Spain or Italy where English is not that much common, there could be some sort of a translation which needs to be done by official translators, so that whatever is translated in the same sense as it is written in English or any other language. Very importantly, inherent mindset of judges. Most of the times, when we look at US courts or the UK courts, the insolvency courts, they're very fast, they're very quick. Simple reason being that the inherent mindset of judges is in tuned towards faster resolutions. They understand that maximization of value of assets cannot happen if they are not fast in their orders. The more time that elapses decreases or destroys the value in the asset. So this thing has to come into the minds of Indian judges as well when we have to go very fast on things which sometimes take 3 to 4 months, need to be done in hours. That is very important. Definition of courts in various jurisdictions. Yes, like I said, there might be administrative courts, there might not be judges, there might be administrative staff handling insolvency courts. That has to be taken care of. Resolution of a substantive issue needs to be taken on the jurisdictional basis, because we are not coordinating on substantive law. We are only coordinating on procedural law. Like in India, we have lack of rules and regulations and legislative framework on international cooperation on conformity and reciprocity. So that has to be done at the back end by the judges themselves. Rules of procedures are different in different court that have to be taken into account. For that matter, there are protocols. I'll be coming to the protocols in the next slide. Mode of communication could be these days Zoom calls, telephonic calls, could be. I've not seen it, but I've read that earlier there used to be telex communication as well around 20-25 years back. There used to be telex communication as well. But the mode of communication today is very fast. Zoom calls, Meet or team calls, telephone calls between judges, between IRPs, between the court and the IRP and the RPs takes place on regular basis to apprise the judges of what is happening in different jurisdictions, so that they can take a call on what needs to be done.
Sir, sorry to interrupt you. We will have to conclude in 5 minutes. I'm sorry, the time by. We will have to conclude in 5-7 minutes.
Can we take a break?
No, sir, we will have to conclude by 15 or.
Okay. Potential impediment to cross-border legislation: speed, timely intervention. Our adjudicating authority needs to be sensitized towards the speed of the working, executing the basic principle of insolvency and their implementation and direction by the adjudicating authority, application of principle of public policy in its process. It need not be very strict. It should be very, very soft. Adjudicating authority have more powers of self-determination in cross-border insolvency. So what is it for IPs, Indian IPs? Right or direct access to foreign courts. They can intervene in foreign insolvency process. IPs may be appointed as authority for foreign representatives in India. That's inbound. Can be appointed foreign representative of Indian insolvency representative in Indian CRP to pursue debtors' assets in other jurisdictions. This is outbound. Duty to act judiciously. Any misconduct may have consequences for IPs in foreign jurisdiction and also be subject to scrutiny by the board. Duty to be bound by the principle enshrined in the upcoming legislation, that is the part G that I'm talking about. In case of cross-border scenario, expert knowledge is required, which may result in better monetary benefits for the Indian IPs. So just for the information, this is one publication we did with Insol International, which had people from 31 jurisdictions coming together, which was headed by me. This is not 29 jurisdictions, but 31 jurisdictions. At that point in time, that was finalized. It was finalized. It became 31 jurisdictions, and this project was headed by me. And almost all formal insolvency processes are given in this 400-page book. which can be downloaded from Insol International website. Thank you very much. If anybody has any questions, I'll be more than happy to answer.
Any questions from the participants? I know this is a technical and little challenging topic. However, when we also couldn't give enough time to Mr. Gupta to explain also.
So if there are no questions, should we wind up for this session?
Yes.
Yes,
Thank
sir,
you
I
so
think
much
we
for
can
this
wind up.
wonderful session.
Attorney,
I would like to thank Rocky sir. Thank you so much for this wonderful session and sharing your perspective on cross-border insolvency. I would like to call upon Mr. Ashish Makija ji to kindly present a memento to our speaker, Rocky Ravinder Gupta ji.
Thank you, Makija ji. Thank you very much.
Ashish ji, are you
Now
there?
I would like to invite Mr. Vikas Jain. Thank you, sir,
Please proceed,
for
Somaji.
accepting this.
Thank you, Mr. Gupta.
Thank you. Thank you.
Thank you.
Yes. Now I would like to invite Mr. Vikas Jain to introduce our second speaker of the day, Mr. Gajesh Jain ji. Mr. Vikas Jain.
Let me introduce our second speaker today, Mr. Gajesh Jain. Mr. Gajesh Jain is an chartered accountant. He is also an international MBA, a law graduate, and also an insolvency professional. So he has been a strategic leader in practice since last more than 17 years. And he has experience of steering portfolios worth more than 10,000 crores in various areas like real estate, hospitality, healthcare, education, etc. He has a team-based management style coupled with zeal to drive visions into reality. He has been instrumental in multiple projects in India as well as in Maharashtra in primarily. He has been experienced in funding of various star projects as well. He has been a partner of S. Jain Bora and Company since 2022 and has been a director of Renaissance Insolvency Resolution Professionals Private Limited. He has a wide experience of working as an Indian industry with India Bulls, ILFS, etc. And Yes Bank before that. With this brief background, let me introduce today's speaker, Gajesh Jain. Over to you, sir.
Thank you, Mr. Thank you for the brief introduction. Thank you, Mr. Makija, for inviting me on the platform IPNet. And thanks everybody. First of all, be thankful to everybody for your patience listening. Initially, thank you, Bol Deta, sir, so that everybody's awake. So Saturday evening, sir, I'll not take much of your time and energies and efficiencies because we all are insolvency professionals. We have some or the other botheration, talking on our head at the back of the envelope. So I think R.R. Gupta ji has set a very strong platform in terms of technical legalities. So I wouldn't ponder upon the technical perspective of it, though I have some slides. So preferably I'll skip those slides and move on directly to my experiences, etc., which would make more sense towards what I am supposed to speak about, if I may be allowed to do so, sir.
Yes, sir. Let us proceed to your interactions and experience with cross-border insolvency.
Yeah. Thank you so much, sir. Thanks a lot. So what is cross-border insolvencies? I think sir has covered in-depth ways, so I wouldn't ponder upon that. And from my perspective, what were the key reasons? That was more important, probably why I went ahead and what was my thought process. Probably that is more important towards what other members would like to understand. See, yes, there are some broad parameters, of course, global asset distribution. I mean, we had some. So let me give you the brief background of first what happened initially. Then we would quickly ponder upon why we thought about it. So initially, Compuge Infocom Limited, it was one of the largest, I think, one of the largest IT distribution companies, which had around turnover of around 4,000 crores or so. Their major business being 100% business being IT and IT enabled hardware and software distribution. So they also had a branch in Singapore, where certain amount of monies were lying there, inventories were lying, and per se as an RP of a company, I couldn't take charge of that. This company defaulted somewhere, the loan, etc., and this was initially insolvency was admitted on 2nd of November 2024. So later on, we realized that we are having difficulties in terms of having a control on the assets of Singapore branch. In the books, it was a good amount. I would refrain that mentioning about much of details, but the amount was good. The monies were lying over there. And when we tried transferring that money to Indian account, because that money and inventory belonged to per se subsidiary, not subsidiary, sorry, the branch which was of the corporate debtor. So there we had an issue because technically, since there was no recognition of insolvencies abroad, we couldn't get that money back. And the banks, etc., also raised objections to us that, your insolvency per se is not recognized in Singapore. So please get me Singapore High Court's order for changing your authorized signatories uh, and repatriation of money on if you want to do anything, etc. So that way, that's where we click this idea of getting cross-border along with that. Per se, we knew that, there is no parallel insolvency and bankruptcy code that is going on in Singapore. So the best way for us was to approach Singapore High Court. So we started doing our research work. We understood, how there was no precedent to whatever was done, but then always there is a chance that, we can succeed and we can be setting an example somewhere. That's how the journey began with us. We did a deep research on that, how it can happen, etc. Incidentally or coincidentally, I also attended a couple of sessions with Mr. Patwardhan as well, where he was a speaker and took some guidance with regard to Komi. Komi, yes, is very important. I think Komi was the setting example from my thought processes that, how we can frame our application, how everything has to be done. Common interest, common management, employees, etc. I think that was the precise reason. That's where the lawyers also helped us out understanding how we can bring this money back or how this recognition can happen in Singapore. I think we spend a lot of time, especially with Singapore, India, etc., when drafting and understanding and making them understand why Komi is India and not in Singapore, very candidly. Almost months passed by in that. Why Komi is India and why not Singapore, etc., etc. But finally, I mean, all well that ends well, kind of. Now, keeping certain perspectives, what we learned, what, the order of Singapore High Court mentioned about it. So I just wanted to take a step and make you understand or try to make my fellow insolvency professionals understand about it. Singapore High Court, they analyzed one case, Astrica Holdings, where they said the proceedings must be collective in nature. It must be collective in nature. For them was something like, we also admitted that, sir, that, whatever is happening in India has to be equitable, fair. The treatment to the creditors per se, whether in India or Singapore, have to be equitable. So that was the first comfort which we wanted to give to Singapore High Court, that we are not here to cut the corners. We are here to take everybody along together with us, whether it is Indian creditors or Singapore creditors. Everybody will be treated at par with each other, whatever the category is. So we tried convincing them that your operational creditors per se would be treated equally the way Indian law is treating Indian creditors. Then the proceeding must be a judicial or administrative proceeding in foreign state. That's where we are. I don't have to explain that it was definitely proceeding in a foreign state and administrative proceeding as well. The proceeding must be conducted under law relating to insolvency or adjustment of debt. IBC is the one law that is prevailing in India. The property or affairs of the debtor must be subject to control or supervision by a foreign court in that proceeding. Now that's where there was a point that this must be done under the control of the supervision of the court proceeding. NCLT is something for us. However, over there it is Singapore High Court. And the proceeding must be for the purpose of reorganization or liquidation. So we wanted to get this money back, of course, for the purpose of either CRP cost or maybe distribution, whatever. But that the control was something which we were looking at. So we satisfied all these perspectives, which is also mentioned in the Singapore High Court's order as well. And then the court had very fine observations with this order as well, that in concerns to all creditors of debtor generally, and it is instigated at request and benefit of a single secured creditor. A consideration is whether substantially of a debtor assets and liabilities are dealt in the proceedings. They mention that judgment per se, and it considers the rights and obligations of all the creditors. So they specifically mentioned everything about it, and they said that what again I said that whatever I said earlier, that we ensured court that we are here for equitable purposes. We are not here to do any disparity. We are not here to do any disruption. We are here to follow the law in terms of Indian IBC as well as whatever Singapore High Court will direct to us. However, for us, the paramount importance was to take the control of cash, to take the control of inventories, and also abide by to the Singapore laws. Now, when I use Singapore laws, etc., the first perspective which we understood and which we wanted and explained to the lawyers, probably that took us a lot of time. Then each and every compliance that is to be carried out, had it been assuming that the Singapore subsidiary was live or as a going concern, has to be carried out, be it whatsoever, employees' liabilities, or filing of ACRA, that's what we call something parallel to MCA, what we have here. The filing should be there, the balance sheet should be signed. If you have any observations or qualifications of auditors, that needs to be addressed. Similar to whatever GST is there, income tax payments, etc. Everything has to be clean, justified. It should be like a clean state, and it should not be projected, or it should not be understood by the court that we are here for any evasion or any breaking of any law that is with respect to Singapore. So that is something we equitably ensured, and thankfully so the COC also understood the perspective and everything, and they helped us out in terms of doing the compliances, bearing the cost, understanding the perspective that we are trying to achieve with. And of course, it is a beneficial thing because ultimately recognition, if it happens, then we get the control of assets which were lying over there. Foreign court and all, foreign representative, I think Mr. Gupta ji covered about it, so I wouldn't ponder about that. For me, Komi, yes, yeah, anybody wants to say anything?
I have a query.
Yeah,
Was
sure.
it contested by the promoters in Singapore against you? Because you approaching court and satisfying court is one part, and any other party contesting, maybe local creditors, local employees, or promoters.
I would come back to it, sir. My order is still not completed, and I am supposed to do some things. So I would. It's quite interesting, sir. But sir, please allow me for 2 minutes if you don't mind. Sure, because the last line of the order per se and whatever we are doing now, it's quite interesting.
Sure, sure.
So sure. But thanks a lot for asking this question. So we are going to the next level of it. Komi per se. That's quite interesting. Komi per comes, I think one has to understand and ponder about Komi everywhere. if you have to go cross-border. That's what I would say. I wouldn't discuss about Komi in detail because R.R. Gupta Sahab has already covered Komi very much in detail. But however, all I want to say is their common interest is a key to everything. This really decides your jurisdiction per se. Whether your application has to be admitted or dismissed, that will be decided by Komi. To certain specific the order is in front of you or the order has already been out. So I would just say a couple of points that the Indian RP is currently being treated as equivalent as a foreign representative and the liquidator in Singapore. So he has all the rights and obligations as well to comply with laws or compliances that need to be carried out over there. One has to be extremely mindful of what he is doing because one side he has to comply with Indian laws. On the other side, he also has to take care of compliance in Singapore. It looks like, you have a cherry on the top, but on the other side, it is a double-edged sword as well. On one side, you have India compliances. On the other side, you also have Singapore compliances, which needs to be carried out. Earlier on, we had only one court, that is NCLT, monitoring us. Now we have another foreign court monitoring us. So though it was recognized, we have control, we are trying to do whatever best we can in terms of taking control of the asset or bringing the money back, etc. But when it comes to repatriation of money, probably that is the hindrance. That's what they created. Initially, they said that you do everything over here as far as recognition and everything is there, the compliances is done. When it comes to repatriation of money, you please approach us once again so that we are doubly sure that whatever has been done is taken, whatever has been promises is taken care of. Meaning thereby, whatever we promise that, will be equitable, we are not here to disperse any proceedings, we are going to comply with everything, we are going to carry out the process, etc. You do everything over here, show it to me that you are having a good intention. When it comes to repatriation of money, please do come to me once again. And once everything is carried out, only then I'll allow repatriation of money. That is the last leg or the important leg which we are supposed to carry out. Now, challenges, that is something everybody wants to understand. What did you face or experience equals to challenges on these scenarios? One is, of course, the regulatory compliances which we had to do carry out. It took, again, months and months for us to carry out all the compliances. Financial statements, income tax returns, GSTs, etc., employees taking care of and justifying that, we'll take care of employees, etc., whatsoever the claims are. Secondly, as I said, legal credibility. That's what we said that, we are not here to evade tax. We are not here to do any violation of Singapore law. And most important thing, that's what we tried establishing that. And rightfully so, which is also mentioned in the court's order, that we are not here to contravene any of the public policies of the Singapore authorities. No evasion, no violation, no contravention of public policy. I think if you get that kind of comfort, if you give them, that kind of comfort, that please allow us to do something here. That's where what we got an order stating that if you're not contravening anything, if it's not evasion of tax, it's not violating any Singapore law, then probably I am trying to treat you as equitable as as a professional, as a foreign representative in Singapore. Transparency, by and large, I think we maintain equivalent amount of transparency everywhere. The lawyers did help us out. They said that Gajeshji, we have to be transparent. We have to carry out everything that you have done in Singapore. Everything has to be minutized. We have to share the minutes. Everything has to come on the websites. You have to do publications. you have to be very vigilant in terms of transparency and letting the world at large know about it. Now, coming back to what Patwardhan sir said that about A, objection, B, promoters. So promoters, I think there was, since I had the control, etc. So legally we were able to convince them that it is a branch, it is a part of the company, it is consolidated in the company. So I have all the rights to take the control of foreign assets, which is also mentioned in the code. That is, I think, section 18 of the code, which says that the RP is supposed to take the control of foreign assets as well. Though, I mean, foreign asset is just a two word, but it takes months and months for us to take control of that. But yes, somewhere we were able to convince COC and the past suspended management as well. Now, second perspective, compliances. So prior to going to court as well, we tried intimating all the creditors over there that this is, look, this is what we are trying to do. This is the thing which we are doing here. If you have any objection to it, please let us know. In fact, to that extent, I would go ahead and say, which the order also mentioned, that I already meant we have admitted 95% of the claims of Singapore branch. Thereafter, also to satisfy the court, etc., we had to carry out certain publications, just as the way we do in India for Form A. So something parallel or equivalent to Form A was carried out. So we are still having in the process of doing certain things. So I would refrain answering this question completely. But to that extent, what I want to answer Udaybaraj Patwardhan sir is that we were able to convince the promoters that this is the part of the company, and foreign asset is something within the purview of the court, which the RP should take control of that. And compliances, creditors, objections, we are trying to deal with them meticulously, trying to be as transparent as possible with all the creditors. We are trying to satisfy the court as well that there is no objective to evade the tax. We will take all the creditors equivalent at parity with each other. We will not discriminate between Indian creditors or Singaporean creditors. Of course, the class of creditors would vary. And we are here to comply everything, each and everything, whatever is there. So that was the mood mantra, I would say, that, we went ahead. Of course, the legal perspectives, Komi and other perspectives were there, which was obviously discussed in depth and at length by R.R. Gupta, sir. So I wouldn't take up that matter. We are not here to discriminate again. From my side, that is the whole and soul summary of within 15 minutes is something I wanted to share the experience. Of course, I'll have to be mindful that I'm still running the show. So show in the sense I'm in the position of an RP or a foreign representative. So I'll have to refrain myself barring out any, passing out any information that I feel is confidential. But having said that, in short, that is the summary of what I have done till now. And I really want and wish that, the government also takes it up positively. And in the amendments, if not now, later on, we get some good news about recognition of cross-border insolvencies and bilateral agreements, etc. And the new opportunities also come up with the insolvency professionals, and we look at something different. We try to look at something different what we have been doing. That is what I would say. Anybody has any question, queries? Over to everybody.
If anybody has any query, I will start with again one of my query is as per the model law, the creditors in a foreign country cannot be put at a position which is worse than what they are in Singapore. So maybe from out of Singapore assets, their recovery could be say 100%. And if you admit them in India, the recovery could go down as per Section 53, maybe to 20%. I'm just doing an assumption. So
Assumption.
how did you address that issue, and how did you satisfy the court on that?
So we just said simple things, we said, see, the process over here, see, I understand from where you are coming. So Singapore does not have CIRP procedure. Singapore has only liquidation process, number one. Number two, so that's where we didn't ponder around with Section 53. We didn't touch base with that. That's something I wanted to address. Secondly, we made them very clear with respect to CIRP. Even the order mentions about that. We tried doing explaining them what is CIRP. It is unlike, it's not a liquidation process, but it is a resolution process where the bidder would come and give a value to it. And the bidder has to be fair and transparent. And there is a committee that approves the entire plan, and thereafter NCLT or equivalent, NCLAT or whatsoever, any adjudicating authority would be approving that plan per se. So everything has to happen in a framework that is called IBC 2016. Under that, I'm trying to get a recognition in Singapore. Court was also happy stating this way that you are giving us an equitable treatment. That is the Singapore branch per se. The creditors of Singapore branch have been given equitable treatment. So there is nothing wrong in that. Of course, financial creditor would be treated as financial creditor, and operational creditor would be treated as operational creditor. I hope I've answered this question to you, sir.
Yes, sir. Yes, sir. Yes. Any other queries that other participants may have?
I have a query in respect. Actually, I was discussing 2 days back with one of the banker. Like in case of personal insolvency, can I ask something about personal insolvency? Regarding there's a person who was given personal guarantee, and now he's become a citizen of Singapore, and here in Singapore he has the assets. Whether we can have any law in India, whether we can do anything. He has defaulted. He has given a personal guarantee. He has defaulted, and now he become and the CRP is admitted in. Personal insolvency is admitted in India, but now he's become a citizen of Singapore.
Not technically, sir, but the one thing I wanted to ponder and which I didn't mention earlier was NCLT jurisdiction is not allowed abroad. So you either any of the high courts or Supreme Court's jurisdiction is allowed. So this is something which we have faced very recently, and that any monetary compensation, etc., which comes up, or if anything, any litigation that comes up from there to India, then probably Singapore High Court or anything will have to be addressed in High Court than in NCLT. So that is something tricky. That's something different. As far as your question, Singapore resident, you will have to consult to your lawyer. I am not right now in a position to answer that question. But to answer the other perspective, had it been an Indian citizen, then probably you will have to again go to Singapore High Court and take an approval that, boss, I want to take control of that asset. And if so be allowed, then probably somebody can, if it is allowed, then probably yes, you can take it up. But again, your intention, you have to prove your intention. That is more important. That's what I've understood in the journey of 9 months, that you have to prove them that what is your intention. Your intention is to treat everybody at par.
I will add here something, Nitinji.
Sure, sir.
The UNCITRAL model law which Singapore follows and which we show to them covers everything, right from individuals to companies to corporates all together. So it in a broad way applies to everybody. So in principally, you can always try to approach Singapore High Court for addressing this issue. I don't see any harm. They will treat it just like a CIRP, as Gajeshji has been trying to get it recognized there. So a proceeding against an individual also can be recognized in a similar way. I think you could try that. That will be worthwhile.
No, his question, to addition to that was, sir, just to add to your point, that he has now become a Singapore citizen. So an Indian guy, if he's if he is treated under IBC, then NCLT jurisdiction is the one that applies. But when it comes to the guy who has becomes a foreign citizen, how would be treated? That is why I said
It's a tricky issue. A lot
it's
of
a tricky
legal
issue.
entanglements in it.
Yes.
But yes, it's worth doing it if you feel that the creators are ready to fund the process. Because let me tell you that this is the costly process. Even in India, insolvency is a costly process compared to others. And if we are talking about approaching foreign courts, it's even more costlier. So we have to be careful about the cost aspect as well.
Yeah. Thank you.
Any other queries that we may have? Thank you. Thank you, Vijayji. I think there are no further queries. Sonuji, are you there to conclude the session? Ms. Sonu Gupta? Ashish ji is also in US right now. So he was there when we started the session. However, if he's there, I would request him to present the memento to Mr. Vijay Jain. I'm sharing it on the screen. It's a virtual one. Physical copy we will share with you. Soon it will reach you, sir. So
No
on
issue,
behalf
sir.
of
No issue.
Ashish Makijaji, I am sharing this with you. And the physical one, we will send it across to your office, sir. Thank you. Thank you very much, sir.
Thanks a lot, sir. Thanks a lot for your invitation, kind invitation per se. And I really hope that I am able to bring in some thought process to my fellow RPs with regard to cross products in insolvency. Though this is at a very, very nascent stage, but I think we can make some wonders out of it.
So today we had a very new topic about cross-border insolvency. We all try to learn about it, but experiencing the same is very critical. And we are fortunate that we have Mr. Gajesh Jain with us, who shared the contours of whatever is the case and how he experienced the finest of, I would say, courts in the world, that is Singapore jurisdiction. It is considered to be very fine court with very fine law and interaction, and they have, as he has rightly said, they want it to be transparent, and they want to treat everybody equally. That is, no discrimination against anybody. So we will keep on trying new subjects like this, and we have members from IPNet only. That today Mr. Rocky Gupta as well as Mr. Gajesh Jain are our own IPNet members, and I'm hopeful that we will be able to do much more interaction with them in future as members as well. So with this, I call upon IPNet South for declaration of the next webinar. Anybody from IPNet South? So we don't have participants declaring the next webinar. So next webinar will be on the next Saturday. That is on 26th of April, and it will be hosted by IPNet South. And if Mr. Sumit Dadda is here, I would invite him for the vote of thanks. I think Sumit ji also is logged out somehow. So I thank very much Mr. Gajesh Jain and Mr. R.R. Gupta for taking time to introduce us to a very new topic, that is cross-border insolvency. And as R.R. Gupta ji has looked at it, it's a very technical subject that we will have to bear in mind. However, when we are dealing with it on practicality, our earnest efforts, our honesty, And transparency is the only thing which will sail us through. And in the background, we should be able to run the process with the concept of Komi in mind, because if your proceedings are considered to be considered as foreign main proceedings, and if the control is to be remain with you, then the Komi has to be with you. So with this only brief background, let me conclude today's webinars. Thank you very much. Thank you for joining. Have a nice and good evening ahead.